And I congratulate my honourable friend for North Devon on securing this debate, which is of great importance to my North West Norfolk constituents and obviously to members across the House. And in my remarks, I want to focus particularly on the sentence for causing death by dangerous driving. In the Police Crime Sentencing and Courts Bill 2022, Parliament legislated to increase the maximum sentence for this crime from 14 years to life imprisonment. We did that to reflect the devastation that such crimes inflict. And the sentencing guidelines issued to reflect that change have a range for the Category A offence, the most serious offence, from 8 to 18 years. But are those guidelines effective, and are judges following them? In the case of my constituent, which I confirm is not an active case, my constituent Summer Mace, I don't think that that was the case. 3 members of her family, her mother, her sister and her stepfather, were killed by a dangerous driver. And the reason I return to this topic, having had an adjournment debate on this case, is the devastating impact that that case has had on Summer, her family and her friends, and the inadequate sentence that was imposed in that case. The judge rightly classed this as a Category A offence, owing to prolonged, persistent and deliberate course of very bad driving. And in the case, there were 6 aggravating factors. 3 people were killed, greatly excessive speed. The driver knew he was deprived of sufficient sleep, consumed drugs above the legal limit, previous convictions for motoring offences, and he was on police bail for a driving offence at the time and broke the curfew to commit it. The only mitigating factor was a letter he sent to the court, not even to the family. And it's unacceptable after a guilty plea was taken into account, he was only sentenced to 10.5 years for 3 separate counts of causing death by dangerous driving. He could be out in 7 years. And the question the family have, that I have, is what is required for a life sentence to be imposed. Those sentencing guidelines took effect in June last year. And when more data is available, I hope the Minister and the Lord Chancellor will consider very carefully the impact on sentencing that those guidelines have had and whether judges are actually imposing the sentences that this House and the other House legislated for, and the Lord Chancellor uses his power to formally request that the sentencing guidelines are reviewed. The other point I want to raise is one that my honourable friend has touched on around disqualification. In my constituent's case, a ban for a period of only 8 years was considered appropriate, extended to 15 years to take account of time the offender will be in prison. Again, that strikes me as far too lenient. Courts can impose lifetime bans. Road Peace is campaigning for them to be applied. The House of Commons Library reports that disqualification for life only happened in 4 cases in the year to 2023, June, out of over 116,000 who were disqualified. The government should consider whether it should become a mandatory element in some cases, because, as my honourable friend said, driving is a privilege and not a right. And on this issue, the Sentencing Guidelines Council will be shortly consulting on new overarching guidelines on driving disqualification, which I encourage everyone with an interest in this topic to respond to. And I end by noting the frequency of driving offence cases. I was struck by the statistics that in the case of driving under the influence of drink or drugs, 79% of cases result in a fine, with only 1% resulting in a custodial sentence, with 99% of people disqualified for that offence for a year to less than 2 years. Does that reflect the seriousness of the crime? Does it create a deterrent effect? I don't think so. We need to apply a robust approach, including prison sentences and lengthy bans, to send a message that these are serious crimes with serious consequences.